Hello everybody, and welcome to History Bite number 49, dated September 21st, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Loving versus Virginia, 388 U.S. 1, 1967. The Loving versus Virginia case, handed down 53 years ago by the U.S. Supreme Court, struck down all remaining anti-miscegenation laws in the United States. Anti-miscegenation laws, of course, prohibited interracial marriages. At the time the Loving decision was handed down, 16 U.S. states still had actively enforced laws on the books which prohibited interracial marriages, aka, in these circumstances, marriages between whites and non-whites. Now, the level of their prohibition and the severity of punishment for violating these laws vary greatly from state to state. All right? Specifically at issue in Loving was whether or not Virginia's 1924 Racial Integrity Act violated the 14th Amendment to the U.S. Constitution, its Equal Protection Clause, to be more specific. And the Supreme Court held in a unanimous 9-0 opinion, speaking through Chief Justice Earl Warren, that not only did Virginia's 1924 Racial Integrity Act prohibiting interracial marriages violate the 14th Amendment's Equal Protection Clause, but it also violated the 14th Amendment's Due Process Clause as well. Warren contended, speaking first on the Equal Protection Clause, that even though the law punished both blacks and whites equally, the mere fact that it made the criminality of the act itself contingent upon the race of the actors, that alone, ran in contrast to the language and spirit of the Equal Protection Clause of the 14th Amendment, and was therefore unlawful under that provision, Next, he contended that the Racial Integrity Act violated the Due Process Clause of the 14th Amendment because, quite simply, marriage was one of the fundamental and basic civil rights of mankind, so fundamental and so basic and essential to a well-ordered and well-structured society that the right to marry or not to marry, a person of a different race resided with the individual and could not be infringed by the state, The state could not legally prohibit one of the most basic civil rights of man merely because the persons were of a different race. They'd have to do far better than that. So that's how it violated the Due Process Clause of the 14th Amendment. Also contained in this case was a concurrence by Justice Potter Stewart, who wanted to emphasize the principle that no law could exist in our constitutional system whereby the criminality of an act was dependent upon the race of the actor. That is unacceptable. That was entirely unacceptable under the 14th Amendment. Point blank, done deal. So, to recap, Virginia's 1924 Racial Integrity Act, which prohibited interracial marriages in the Commonwealth, violated the 14th Amendment's Equal Protection Clause and its Due Process Clause. It violated the Equal Protection Clause because even though the law punished both blacks and whites equally who violated it, nonetheless, it made the criminality of the act solely contingent upon the races of the actors, Race was the sole determination of whether or not this was a crime, the crime of getting married and being of opposite races, It was exclusively race that made the act criminal, And therefore, that was illegal and ran contrary to what was required by the 14th Amendment's Equal Protection Clause. Next, the Virginia's 1924 law violated The Due Process Clause because marriage was one of the fundamental civil rights of man, okay? So essential, so fundamental, so basic to all mankind that the right to marry or not to marry a person of a different race resided exclusively with the individual and could not be infringed by the state, okay? And of course, Justice Potter Stewart included his concurrence that no law could exist in our constitutional system that made the criminality of an act solely dependent upon the race of the actor involved, okay? That is entirely unacceptable and not permitted under the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. So that is the gist of Loving versus Virginia, okay? Like I said, it was a unanimous 9-0 opinion written by Chief Justice Earl Warren, okay? This case is truly landmark and it has had a profound effect on American constitutional law, okay? It is just as arguably powerful today as it was when it was handed down in 1967. And unlike a lot of other decisions handed down in that era, this one was one of the few which the southern states accepted without a whole lot of kicking, unlike Brown versus Board of Education 12 years earlier, all right? So like I said, that's the gist of Loving versus Virginia. For more information, look that case up. It is referenced under 388 U.S. 1, 1967, Supreme Court of the United States, okay? So I thank you very much for listening to this History Bite. I hope you learned a thing or two from it. It gives me great pleasure to teach case law in these History Bites as well. That's another one of my passions, obviously. So I invite you to keep listening to these History Bites, continue learning, spread the information. Take care, stay safe out there, and I'll talk to you at the next one. Peace.